Sexual assault on campus. The simple truth about Title IX that colleges don't want you to know. What is Title IX? It's a federal civil rights law for women and girls that says, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Title IX guarantees women equality in education. It also prohibits discrimination, the most severe form of which is violence, including sexual assault. When sexual assault happens, Title IX affords victims maximum legal protection for their rights and well-being. Some members of Congress, both Democrats and Republicans, and even many women's rights groups are distracting our attention from the fundamental power of Title IX as a civil rights law. They are making things needlessly complicated by supporting affirmative consent laws, the Campus SAVE Act, and the Campus Accountability and Safety Act. These seemingly helpful measures not only obfuscate the truth, but also threaten women's equality and safety by undermining Title IX. Now let's talk about how simple Title IX really is, and why it's so important for all schools to enforce Title IX, and only Title IX, when sexual assault happens. Sexual assault is never just a night of bad sex. It's a violent felony. And when it happens in connection with education, it's a civil rights violation too, because it interferes with women's equality and ability to learn. Police and prosecutors in the real world are obligated to address sexual assault in criminal court, even when it happens on campus. School officials are separately obligated to address sexual assault on campus as a civil rights violation. The laws that apply in criminal court are very different from the laws that apply on campus, and victims are entitled to seek justice in both places. It is illegal to ask a victim to choose one or the other. Civil rights laws, including Title IX, have guaranteed women's safety and equality on campus since 1972, but many people think of Title IX as a sports equity rule. So when a student is sexually assaulted, the victim and her family are typically unaware that a civil rights offense has occurred. What does Title IX require? Title IX requires schools to address violence against women under civil rights laws. If they don't, they are subject to investigation and sanctions by the Office for Civil Rights at the Department of Education. Many advocacy groups have close ties with schools, and they don't tell victims the truth about their rights under Title IX. Being well informed about civil rights laws is as important as getting good grades. Here are 10 things to know about Title IX. 1. Title IX guarantees women equal access to education and forbids discrimination on the basis of sex. The most severe expression of discrimination is sexual harassment in the form of violence, such as sexual assault, dating abuse, and stalking. 2. Title IX matters must be enforced promptly. Promptly means an incident must be resolved within about 60 days. Some schools try to run out the clock in the hope the victim or perpetrator graduates before a final decision is made. 3. Title IX must be enforced equitably. Equitably means an incident must be addressed under exactly the same standards as violence on the basis of other protected categories, such as race and national origin. 4. Title IX must be enforced effectively. Effectively means the school must successfully stop the harm from occurring on behalf of the individual victim and women as a class. 5. Many schools offer two very different redress options, one under civil rights laws such as Title IX, and the other under generic student misconduct codes and the Campus SAVE Act. 6. Students whose incidents are handled under generic misconduct codes, or the Campus SAVE Act, are subjected to worse policies and procedures compared to incidents addressed strictly under Title IX. 7. Title IX violations require proof that an incident was unwelcome and offensive. This is much easier to prove than non-consent and force, which apply to generic Student Misconduct Code violations and the Campus Save Act. Even affirmative consent and yes means yes rules are more difficult to prove than unwelcome and offensive. 8. Title IX violations require only a preponderance of evidence, which means if a victim is slightly more credible than her assailant, the school must take action and the action must be effective. Under generic misconduct policies and the Campus Save Act, schools can require much more proof than mere preponderance, and the response need not be effective. 9. Many schools require victims to talk to a particular advisor or counselor before making a formal report, but the recommended advisors and counselors are often aligned with the school's interests and may persuade victims not to file formal complaints. This advisory process inhibits enforcement of Title IX and allows schools to undercount true incidence rates. It is much wiser to first tell a parent and/or trusted attorney with no connection to the school. 10. Hospitals nearby to schools, and even specially trained nurses such as SANES, sexual assault nurse examiners, are often aligned with schools and may not take appropriate medical and forensic steps. Victims should obtain medical and forensic care from a trusted provider unaffiliated with the school. A few final thoughts to consider. Many in Congress who purport to care about women, McCaskill, Gillibrand, Leahy, Maloney, Boxer, Casey, Grassley and Blumenthal, are responsible for passing the SAVE Act and weakening women's rights under Title IX. These same officials are now supporting another bill called the Campus Accountability and Safety Act, which will further weaken women's rights and prevent accountability in several ways, including 1. It will require confidentiality agreements between colleges and local police, which means the public, parents and students will not be apprised of important information about crimes against women on campus. 2. It will give schools permission to take no steps against a perpetrator unless the victim files a formal report with a specific campus official after she meets with an advisor or counselor recommended by the school. Lobbyists for higher education are extremely well funded. They propose the SAVE Act and CASA to give schools immunity from lawsuits and to legitimize the wrongful framing of violence against women as something other than a civil rights violation. Even though SAVE and CASA weaken Title IX, many advocacy groups support the laws because they provide new opportunities for advocates to be paid by the federal government to provide training, education, and support services. Women's safety and equality in education should never be compromised in exchange for funding. To avoid having to comply with Title IX and to prevent OCR investigations, some schools have victims file complaints under Title IX, but then, without telling victims, the complaints are downgraded to generic disciplinary matters and Campus Save Act problems. When a school violates Title IX, the victim is often encouraged to file an appeal within the school's internal disciplinary system, but this is usually a bad idea because it delays the victim's access to external oversight agencies and the courts. Victims have a much better chance of protecting their Title IX rights if they appeal a school's decision by filing a complaint with OCR. But remember, OCR will only get involved if the school handled the matter as a Title IX issue. OCR has no authority to help victims whose cases were mishandled under the Campus Save Act or generic misconduct codes. Stand up for women's safety and full equality in education. Demand compliance with Title IX and only Title IX on every campus. You may reach the Office for Civil Rights of the Department of Education at 1-800-421-3481 or 1-202-453-6100. For more information, please go to www.campusaccountability.org.